Lately, Sir Lordship, Counsel D. Gogoi is on legs at court one. Let the matter be taken up after some time.
B. Gogoi is representing whom?
A petitioner.
Which item?
Item one.
B. Gogoi or B. Ghosh?
D. Gogoi, Lord.
His name is not here.
It's authorized by P.N. Goswami, Lordship.
Huh?
It's authorized by P.N. Goswami.
He's not on record, Lordship.
It's not on record, Lordship, but he's
Appearing for the petitioner.
petitioner. Lordship.
My lord, earlier conducted by us, my lord, and they are subsequently filed has been taken by my client, madam. But our name, my lord, Mr. Vijay Ghosh, Mr. Ayalom, and my name, Mr. T. Sheikh, my lord, may be deleted, my lord, from the cause list, since they have presently conducting the case. My lord.
तो पसंद दिया तो बड़े बड़े आटे भी देना पाए. We'll take it after some time.
Obliged. But our name may be deleted. Obliged.
We have not seen that there is no report that any Okalat number has been filed.
My lord, they have
We
appeared,
cannot
my
at
lord.
this moment.
I have already handed over long back, my
But you should file you should write a letter to the
Fine.
party registered post. Give it to us, then only you can consider. Otherwise, not. Take your seat, Mr.
my lord.
Notice in this case was issued on 23/07/2000. Registry also received the relevant records from the Fairness Tribunal number. It was called for by order dated 23/07/2018. While issuing notice, the court by order dated 23/07/2018 observed that till the next date fixed, the petitioner shall not be arrested and deported. The matter has been listed for motion after the order dated 23/07/2018. Almost after 6 years. Issue rule, place the matter for hearing, date to be fixed by the registry. As the petitioner has been appointed to be a foreign national, pursuant to the impugn opinion dated 21/05/2018, passed by London Foreigners Tribunal number 2 Kampu in BFT case number 1080/2016, arising out of IMDT -153/1 of 2002, The petitioner shall appear before the Superintendent of Police Board, Kamrup, at America, on or before 19th and 17th Friday. Ms. Verma, Ms. Sharma. See, brother is just making an inquiry. After the opinion of the tribunal, whether the proceeding was casting his vote on,
Many
because
times. Number
it's not a pre-voter time. So
if he's declared a foreigner, he cannot cast lordship.
we do not know.
And
Whether
this
it
issue
has
has
been-
come up many times. But because they hold a voter's card, they continue to exercise their franchise lordship. Lordship, that was one of my prayers earlier also, that when they are declared to be foreigners, even by this court, then there should be an observation from the court, Lordship, that
Not at all. See, basically,
there are some cases where this court has made that observation that
thing is
they
this,
should not be allowed to
see,
continue to vote.
in exercising the power of the certiorari right, we are only to consider the tribunal's opinion and nothing else. The reference, the competent authority seeks an opinion whether the person concerned is a foreigner or not, right? Under the 1964 order. So it is after that opinion, even that tribunal cannot go beyond that. We have seen earlier the numbers of different kind of direction, seizing of the ration card or anything, whatever. Not to arrest the detain. It is up to the competent authority to decide. Competent authority has sought for an opinion, that opinion has been issued. To that extent, the tribunal has to exercise. Not beyond that.
When the matters have
Now,
reached this court,
that is the difficulty. Here we are also. That is the reason we are asking. The thing is this, where is our that power? We are only related to the opinion of the tribunal. Finding of the tribunal is good or bad. That much. Right?
but in some decisions,
Thing is, that
Lordship,
is why on the last occasion, after about a month back, we wanted to know from the government. That's why we asked the government. That was a case where one person who has been declared a foreigner had his passport and everything.
yes,
So
Lordship.
what mechanism you have?
The instructions have come, Lordship. My friend will file an affidavit.
You know, what
with that.
mechanism you have? Once a opinion is offered, given by the tribunal, what actions you are taking? Even if it is, the High Court is not staying any such order of the tribunal. High Court, when during exercise, if you have seen from all these years, only the deportation, the detention and deportation is stayed. Not to deport, not to detain and not to deport. Not beyond that. Yes. So it is up to the authority to take appropriate
Lordship
action.
will mention that matter one of these days and get it listed. We'll file the affidavit. The instructions are there, Lordship.
Let's see.
Obliging.
Apologies, Your Lordship, I was in court one.
Doesn't matter, Mr. Gugoi, when did you file your Wakalatnama?
My lord, I appear on behalf of Mr. KP Pathak and I Kolita, my lord. My name is not in the
No,
Wakalat.
when did you file, when the Wakalatnama was filed?
I just,
You are appearing?
Yes, yes, my lord, we signed a Wakalat number on 21/6/2018. It was received on it was received on 8/7/2019. I have the receipt, my lord.
Do you have a copy?
Well, I can. Sure. Jangan ambil mereka saya perlu betul.
File to मुझे मेरा पूरा number तो
তাহলে কি? আজি 2019 চনৰ পৰা আজিলৈকে ইয়াতে ৰেকৰ্ডত Wakalatnama খন কিয় নাই? দিব লাগে অলপ। আগৰ মেটাৰটো আহিছে তোমাৰ 12%। এইটো মেটাৰ তোমাৰ আহিলে until further. Notice in this case was issued
Well, there was an interim also, my lord.
on 20/07/2018.
My lord. LCI was called for, my lord.
The registry, the case record of application number 1162/D/11. That was called for by order the 20/07/2018 from the Foreigners Tribunal number 13. Received by the registry. And shall be retained until further order. Issue rule. Release this matter for hearing. As by the impugn order. 30/06/2017. Author by learned Foreigners Tribunal number 13. In application number 1162/D/11. Committee number arising out of reference case number IM in bracket T. R/99/98. And the petitioner has been declared to be a foreigner under the Foreigners Act 1946. Of post 1971 stream. He shall appear before the Supreme Police Court at 3 on or before 21st of June. Shall obtain bail by the condition.
কি করি?
We have seen from the case record that while filing this writ petition, the petitioner shall file a Kalatnama on 21/06/2018 with the names of one I Alam and Mr. P. Sek. In the cause list, there are name of Mr. P.N. Goswami, I. Kolita, and Mr. K.P. Pathak. On verification of the case record, we found that there is no such Wakalatnama on behalf of the set of counsels, Mr. P.N. Goswami,
Yeah.
I. Kolita, and K.P. Pathak. On being inquired, Mr. D. Gogoi, counsel for the petitioner, placed the acknowledgement copy of filing the Wakalatnama in the matter by him on 08/07/2019 by document number 1/22019. The said Wakalatnama filed by the new set of counsels on 08/07/2019 has not been incorporated in the case record, nor their names have been shown in, also not been shown in the case. Registry shall verify the document number 1/2019 by filing number 4243/19-. Registry shall verify and submit its report in the matter on by 15th of November.
Oh, let's see. Oh, well, well.
May please, the Lordship. Lordship matter with password for time being, Lordship. My senior is coming, Lordship. Just
Notice in this case was issued on 24/07/2018. And you can do notice of issued in this case on 24/07. Matter has been listed for motion. Registry already received the relevant records from the foreigners tribunal for one. For petitioner is also an objection. Since as by the opinion. The 25 district of the Karnataka in application number 191 of the 16 variety number I reference case number 598. Declare appoint the petitioner to be according to the post and become appoint the petitioner for it. This shall appear before the judgment of the order of the honor before 25. Issue rule to receive the relevant record. Here.
Maybe. Impugned order, my lord. Page 16.
To notice and 24. They receive the relevant records from the partner staff itself. Not part of that. Interim protect 24 rule this is for okay. As by the impugn opinion. Dated 08/06/2017, passed by the partner staff in Hong Kong, number 7. In FT of L of the case number 550 of 2016, arising out of express case number 77 of the point the petition the foreigner as the part of but illegally entered into danger with it in the some order of 25 It shall appear before the Supreme Police order OJAC, one of the okay. Must. 26/07 for the receive the 11 records for the rule is for as per the improved opinion.
Sixty-three.
Improved order. Dated 08/06/2018, Boswell and Partners have come number 240. In application number 264 of 2017. Appoint the petitioner to be a foreigner who are illegally entered into territory with the Assam or 24 1971. Appear before appoint the police, sorry, Deputy Commissioner of Police, Border, Kamrup, Metro, Honor 219.
Blush.
Notice in this case was issued on 30/07/2018. Hmm? 37/2018. Don't anyone. The registry already received the 11 records from the finance tribunal number 2 complete. That was called for by order at 30/07. Yes, Mr. Khan,
My lord,
whether the proceeding is taken into custody,
no lordship,
you are sure
my lord.
there was no interim protection to you.
Yes, lordship, I have seen, but my lordship, in my file, in fact, lordship, there was a direction, you may not be arrested, but that is not found in the order.
It is submitted by Mr. Khan. But
Here is the IA. Here is the 2018 IA allowed.
I need to know anything.
petitioner is an interim protection. Since 02/08/2018. Should place this matter for hearing on a date to be fixed. As by the imperial order.
It's 60 per lordship.
It is 05/06/2018, passed by Learned Foreigners Tribunal, Kamrup, Metro, number 240. In application number 283 of 2017. Appoint a petitioner to be a foreigner to the Foreigners Act 1946, but illegally entered the territory of India, Assam. From this specify territory of Bangladesh on or after 24/7/1971. It shall appear before the Deputy Commissioner of Police.
May please, your lordship.
Notice in this case was issued on 07/08/2018. Registry already received the relevant reports for finance tribunal. I got number 1 point. It was called for by order at 07/08. The dictionary is an interim perfect in 7/8. So does this matter for carrying as by the impugned opinion dated 25/05/2018 passed by and finance tribunal number 1 Microsoft. With application number PNCN of 30/60. And the other in a reference being made by the Supreme Court. open the petitioner to be a foreigner. The foreigner chapter. But illegally operating to op to get opposed to 2503. Great. It's a appear before the Supreme Court on of before 21st. It's an appeal date.
Obliged.
Adjournment ডাকে নাই না?
না।
The LCR was called for, but list to
Heard Mr. Itas Gupta and senior counsel by
Be that.
as counsel for the petition. Also heard Mr. C. Sharma standing counsel report that who is appearing for central government? Anyone there? Mr. G. Sharma standing counsel from department. There is 2. 6. Mr. A. is standing counsel. Election Commission report that. And Mr. P. Sharma, additional senior counsel, has some confidence for right. So that's what take it.
lower court record was called for, Lord. I am
Yes,
told.
yes.
Actually, no, I cannot call you in something. Facebook पे रखी नहीं। Facebook पे रखी नहीं, करके थोड़ी दिन आइडिया पिक्चर है कि दिन बनाया आया ठीक है सर मान लीजिए No, no, morning. Expiry হয়ে গেছে এই কারণে হয়তো। হুম। ও নিজে ফটো দিতে দেন ক্লাস মানে বলে
Please take your seats.
কপি আছে ভালো থাকে ভাজা ভাজা পরে জানি ওকে দিয়ে দিয়েছি না,
Mr. Dasgupta, the notice was issued to the proceeding on 2nd of July 2007, fixing the matter on 14th of September 2007. The proceeding received it on 6th of September 2007. Then
Look,
CFR
I'm told my court has, lower court record has come.
yes, we are reading from the record.
Oh, okay, I have not gone through it.
Just that is why we are asking you.
Oh, sorry,
to tell us what to do in this proceeding. But she did not appear on 14th of June, September 2017, 2007. The matter was fixed on again on 18th of December 2007. On 18th December, the proceeding filed petition to give another date. Then the matter was fixed on 31st of March 2008. Thereafter, after her appearance on 18/12/2007, 31st of March 2008, 7th of September 2008, 22nd of October 2008, 5th of February 2009, 4th of February 2009, 4th of May 2000, 1st of August 2009, 13th of September 2009, 19th of November 2009, then 5th of March 2010, 4th of June 2010, 5th of August 2010, 15th of November 2010, 28th of December 2010, 5th of March 2011, 5th of May 2011, 24th of July 2011, 13th of October 2011, and ultimately the order was passed on 19th of December 2011. Now, certified copy was obtained for the first time of the judgment and order on 18th of February 2016, duly received. Second time certified copy was obtained on 9th of September 2019. Third time the certified copy was obtained on 17th of October 2019. Now just tell us what kind of order do you need to pass, you are seeking to be passed. After the receipt of notice by seeking time to file a written statement from 2007 till 2011, do you think that this matter should be considered? And if to be, what provisions of law?
So Lakshmi, kindly pick tomorrow. In the meantime, I shall go to the record or at 2
To go to the record, it is here.
tomorrow or at 2 million. Oh, no, not at 2. Tomorrow.
Monday or Tuesday.
Easy. Tomorrow I have a signal in code number 1. Today.
Tuesday.
Tuesday.
On the prayer of just the registry received the relevant records from the Foreigners Tribunal First Morigaon pertaining to FT within bracket D case number 438/2007 that was called for by order dated 29/04/2024. By an ex parte order dated 19/12/2011 passed by the learned tribunal, appoint the petitioner to be a foreigner under the Foreigners Act 1946. And the petitioner agree with the said order, preferred filed this writ petition on 28/02/2020. From the records of the case, we have seen that after receipt of notice, the petitioner appeared before the tribunal on 18/12/2007. Thereafter, she remained absent in the matter. She did not appear and also did not file, did not take any steps. And from 31/03/2008 to 19/12/2011, in such compelling situation, the tribunal passed the impugned ex parte opinion dated 19/12/2011. From the records, it is also seen that the petitioner obtained certified copy of the order that 19/12/2011 on 3 occasions, i.e. on 18/02/2016, 09/09/2019, and 17/10/2019. at this stage, under prayer of Mr. Tejas Guptalana, Senior Counsel representing the petitioner, matter is fixed again on court. Not too practical.
Yeah, Meg.
You can go to the record. Petitioner is allowed to go. Mr. Das Gupta and Senior Counsel allowed to go to the records of the case in presence of any counsel to be.
Worship, my senior is arguing a matter in court number 17. Could it be taken up after some time?
Take your seat. Heard Mr. B. Day, counsel appearing for the petition. And what's your good name? You are appearing for whom? Mr. Z. Sharma, standing counsel from the court. Standing counsel from the court. What are respondent numbers 2 and 3? Also, put it right. Mr. P. Sharma, standing counsel. Sorry, additional Chinese government advocate at rest four, and Mr. Electronic Council. In a reference being made by the Superintendent of Police Court of Hong Kong under Police Inquiry number 158 of 2017. As to whether seeking opinion as to whether the petitioner is a foreigner or not. Learned Foreigners Tribunal First Knockout in FT case number 24 of 2017. After hearing the parties and considering the evidence adduced by the petitioner, by order / opinion dated 17/10/2023, appoint the petitioner to be a foreigner under the Foreigners Act 1956, who had entered into the territory of India from specified territory of Bangladesh on or after 25/03/1971 without any valid documents. Dissatisfied with the said opinion dated 17/10/2023, the petitioner filed this writ petition on 20/05/2020. Issue notice returnable by 6 weeks as Mr. Z. Sharma study counsel from department. Mr. P. Sharma, additional Sharma, Representative, and Mr. A. Ali, standing counsel elected from the executive authorities on behalf of respondent number 2 and 3, 4 and 5, 2 and 3 numerical network, and 5 respectively, no formal notice can be paid. Petitioner shall serve requisite extra copies of this petition 2013 by 04/06/2024 of the necessary airport. Petitioner shall serve requisite extra copies of this petition to Mr. R.K. Devsutri, Deputy SGI, or the response number 1 of the necessary acknowledgement from him. Call for the records of FT case number 24 of 2017 from the Foreigners Tribunal number 1. Foreigners Tribunal First Knockout. As the petitioner has been found to be a foreigner under the Foreign Act, he shall appear before the Superintendent of Police Board of Nagaon on or before 21/06/2024 and shall obtain bail for the condition.
Oblige, Worship.
Heard Mr. M. Mahmood. Just a minute. Notice in this case was issued on 30/08/2017. Registrar received the relevant records from the Fairness Tribunal number 5th Corpeta that was called for by order 30/08/2017. Petitioner is also on interim protection and interim bail since 30/08/2017. Issued rule, list this matter for hearing. They already received the relevant records. It was called for by order 30/2017. Retain the records until further order. Issue rule, list this matter for hearing on a date to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Court or Corporate on or before 21/06/2024 for capturing our biometrics identity condition.
Obliged.
Notice in this case was issued on 01/09/2017. Registry already received the relevant records from the Fairness Tribunal. Nagaon Court number 7 at Lanka, Kotai. The same shall be written. That was called for by order 01/09/2017. The same shall be retained by the registry until further order. Petitioner is interim protection and interim bail since 01/09/2017. Issue rule, place this matter for hearing on a date to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Court or Kotai on or before 21/06 for capturing her biometric condition. Notice in this case was issued on 11/09/2017. Registry already received the relevant records from the Fairness Tribunal, 2nd Nagaon. That was called for by order 11/9/2017. The registry shall retain the same until further order. Petitioner is already in interim protection and interim bail since 11/9/2017. So rule, let the matter for hearing to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Court Nagaon on or before 25 for capturing her condition.
Okay.
No representation on behalf of the petitioner on call. So names of three councils have been reflected in the court. Locally, এই no, no, কারণ এইটুকু করে দেন। Registry already received the relevant records from the concerned foreigners, from the foreigners tribunal Chiang that was called for by order date 1909. The petitioner is also on interim bail and interim protection. Interim protection and interim bail since 1909. List on 60. Locally to 6. The same council. Hi. Sharma. কোনটা রেখে আছে চাই ল'ব বি চৰকাৰ আৰু ই বাদ কৰা 6 এইটো 6 একেলগে
May please, your lordship.
notice in this case was issued on 19/9/2017. Registry already received the relevant records from the foreigners tribunal 9th Barpeta. The petitioner is also interim protection, interim bail since 19/9/2017. List the matter for hearing on a date to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Border Barpeta on or before 21st for capturing her biometrics.
Bless. May please, your lordship.
Just or TV upon notice in this case was issued on 19/9/2017. Registry already received the relevant records from the foreigners tribunal Bongaigaon number 2 at Okapati. Petitioner is interim protection and interim bail since 19/9/2007. Issue rule. Place this matter for hearing when it takes to be respected. बाकी है जो retained officer of the human academy. Petitioner shall appear before the Supreme Police Board of Bongaigaon on April 21st for capturing his violence.
May please, your lordship.
Notice in this case was issued on 19/9/2017. Registry already received the relevant records from the Foreigners Tribunal, Bongaigaon number 12 of LP. That was called for by order the 19/9/2017. Registry shall retain the same until further order. Petitioner is interim protection and interim bail since 19/9/2007. It should rule let this matter for hearing or get to be fixed by the registry. Petitioner shall appear before the Supreme Police Board of Bongaigaon on April 21st for capturing contaminants. Parties continue.
Notice issued on 19/9/2017.
Notice in this case was issued on 19/9/2017. Registry already received the relevant records from the Foreigners Tribunal, Nagaon Court number 10. That's on for number 5. Same shall be retained by the registry until further order. The petitioner is already on interim protection and interim bail. It's 19/9/2017. Issue rule. Place this matter for hearing and get to be fixed by the registry. Petitioner shall appear before the Supreme Police Board of Ojai on or at some Ojai on or before 21/06 for capturing his
All right.
notice in this case was issued on 20/09/2017. Registry already received the relevant records from the Foreigners Tribunal 11th and short court. Same shall be retained by the registry of the part of the petitioner is already on interim protection
Lordship, in this case. No, he was in fact at that time in detention camp. Lordship. Interim orders would be considered in the next that the order passed. Yeah.
Since 2009-2017. Probably she's out now.
Perhaps, Lordship, I have no instruction but actually.
2 years. Complete.
Yes.
The while the petitioner, while the notice was issued on 20/09/2017, it is stated that the petitioner was underrated
Paragraph 17, Lordship.
pursuant to the opinion dated. Opinion of the tribunal dated 06/04. Impugn opinion. Issue rule. Place this matter for hearing on the date to be.
Obliged.
Notice in
May I
this case was issued on 20/09/2017. Registry also received the relevant records for the foreigners tribunal 7 Dubri and Bilasipat. Registry shall retain the same until further order. Petitioner is an interim protection and interim bail since 20/09/2017.
But in this case, my lord, tribunal has traveled beyond the my lord, reference. Reference is my lord, 1966, 1971. But by impugned order, he has been declared foreigner of post 1971.
Petitioner is interim protection and interim bail since 20/09. So leave this matter for hearing. It will be fixed by. Petitioner shall appear before the Supreme Police Order to bring one of the protection on for capturing his liability.
On or before, my lord.
21st.
Obliged.
My lord, the petitioner appeared and got bail in connection with my lord order dated 21/9/2017.
Notice in this case was issued on 21/09/2017. This is in Baksa or in Sarvo?
At that time, my lord,
Which village?
my lord,
Kalija.
Borbeta, my lord. Borbeta. Outside of highway, my lord, that is Baksa, and north side of highway falls under Borbeta.
That's why it is important to specify the village. The registry already received the relevant records from the Foreigners Tribunal for better 10th at Sorbo. It was called for by order 2109/2017. And the same shall be taken to the registry as part of the petitioner is also in interim protection and interim bail since 2109/2017. This will rule this matter for hearing on effective effect. Petitioner shall appear before the Superintendent of Police order for better on or before for capturing hard.
Obliged.
May I please your worship? Petitioner is on bail, madam.
Notice in this case was issued on 2109/2017. Registry already received the relevant records from the Foreigners Tribunal from my account but to at February. It was called for by order dated 2109/2017. The same shall be retained by it until further order. Petitioners will only need interim protection in bail since 2109/2017. It's to rule place this matter for hearing. Petitioner shall appear before the spring police order. Bongaigaon. Sorry, not Bongaigaon. On or before 2106 for capturing her. Biometrics.
May I please your worship? Petitioner is on interim, Lord.
Notice in this case was issued on 2109/2017. Registry already received the relevant records from the Foreigners Tribunal. Was called for by order dated. The same shall be retained by the registry until further order. Petitioner under interim protection, interim bail since 2109. Just the matter for hearing. Petitioner shall appear before the Superintendent of Police order Bulagat on or before 2106 for capturing his biometrics condition.
Obliged, Lordship.
Twenty-three petitioner is affected last.
Notice in this case was issued on 2109/2017. Registry already received the relevant records of the Foreigners Tribunal of brother. That was called for by order dated 2109. The same shall be retained by the yeah, order. Petitioner is on interim protection and interim pay. It's 2109. So let this matter for care to be fixed. But the petitioner shall appear before the Supreme Court Police Order, Koprachar, Honor of Report 2107 for capturing it biometrics of the condition. Notice in this case was issued on 2109/2017. Registry also received the relevant records from the Finance Tribunal 8 for better. It was called for by 109/2017. The same shall be retained with order. Issue rule. Place this matter for hearing on a date to be fixed. Petitioner is already on interim bail. Interim protection, interim. Since 2109. Shall appear before the Supreme Court Police Order for better honor before 21 for capturing her biometrics.
Your Lordship, in this matter, similar order dated 25/24 may be passed.
An ex parte order. The procedure did not appear. Yes,
Yes, sir.
on 2 occasions, the petitioner appeared before the tribunal. On 11th of June 2013, she appeared before the tribunal after receipt of notice. Thereafter took time to file her WS. From 5th of September 2013, the tribunal granted time in spite of her absence without any steps. The matter was transferred to the Finance Tribunal, Bongaigaon, Bayapuri. She did not appear. Thereafter, the tribunal passed the impugned order on 17th of August 2016. literacy filed a review petition before the tribunal. Review was dismissed. So tell us why we should consider.
Your Lordship,
Yes,
this petition is actually for challenging the said orders dated 17/8/2016 and 29/11/2016.
that is why I'm telling you, why should you interfere? It is not that the,
Lordship, while the petitioner, actually the petitioner was engaged as daily labor in Delhi at that period.
that cannot be a ground.
Um, Kindly see your Lordship, annexure, page 36, annexure N.
Just tell us what is the illegality with the order of the tribunal.
Mm,
Where is the illegality? You might have everything. But in spite of that, you did not appear continuously. On 13 dates from 10th of December 2020, from 10th of December 2013 to 17th of August 2016. For 3 years. And without any explanation. You are aware, you appeared. It is not that you won't receive the notice that you could see from the records. So,
Some time may be granted. Your Lordship.
for why? Why shouldn't you time? Place this matter for admission on fourth on the prayer of the council for the petitioner. निकल निकल That's great. No. Notice in this case was issued on 21/09/2017. The registry already received the relevant records from the Foreigners Terminal, Baksa, Ramalpur. The petitioner is already on interim protection and interim bail since 21/09/2017. Oh, पहले वाला retain the records. Issue rule. Registry shall list this matter for hearing. Or you can list this matter for hearing on it to be picked with it. Petitioner shall appear before the Superintendent of Police Board of Baksa, Ramalpur, on or before 21/06 for capturing his biometrics condition.
My please, Lordship. As with the contesting proceeding, my Lordship will find the impugn opinion at page
Notice in this
31.
case was issued on 2009-2017. The registry also received the relevant records from the Foreigners Tribunal. Number 1 nobody. Who will come under
No, now it is under Bazali, my lord. Bazali district. Earlier it was on Nalbari,
your village is Bhadrakochi?
my lord. The Patasarkusi LSC, my lord.
That shall be retained by the registry. Petitioner interim protection interim bail since 2009-2017. Should rule take this matter for hearing on the registry. Here before the Department of Police Border Bozali. Is the
My lord.
notice in this case was issued on 2009-2017. Registry already received the relevant records from the Foreigners Tribunal number 2 Kamrup. It was called for by order to the 2009 and shall retain the same order. Petitioner is already on interim protection and interim bail since 2009-2015. Issue rule. Place this matter for hearing to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Border, Amingaon, for capturing her biometrics on or before 21st. No representation on behalf of the petitioner on fall. Due names of 7 councils have been reflected in the first list. For him. Petitioner is interim protection since 2209-2017. The registry has also received the relevant records from the Foreigners Tribunal. List on 5th for admission. Filing from Sharma. Next day, first तारीख को. Okay, notice in this case was issued on 22/09/2017. Registry already received the relevant records from the Foreigners Tribunal. 6. Gaspur at Sutia. It was called for by order the 22/09/2017. Post the same shall be retained by the registry of order. Petitioner is on interim protection, interim bail since 22/09/2017. Issue rule, place this matter for hearing on it to be fixed by the registry. Petitioner shall appear before the Superintendent of Police Court. Vishwanath Saril on or before 21st. For capturing his biometrics for right. Take. Let's get it. Protection in 22/09. Before the point of police border. This is North Salmara.
Yes.
North Salmara will be under now the South Salmara district or North Salmara part. Can I hear? Sorry, Bongaigaon. Honor before 21st. For capturing his. No representation on public for council. For our petitioner is an interim bail protection since 22/09/2017. Registry also received the relevant records from the Foreigners Tribunal Court of Calcutta. For admission. A attitude side. It will. Very good. Message. First. No represent. 3 count. Interim protection, interim bail since 2209. This also received the relevant records. For the foreigner, 9 for better.
Yes, please, your lordship.
What is considered on your name? Vice. Records. For that. And interim protection, interim cake. By. If we have a prosecutor police or better honor before device for capturing our notice in this case was issued on 2209/2017. Registry already received the relevant records from the finance tribunal. Petitioner has already been released after her. Rule, please this matter for not your contact. About the detention asylum. Notice in this case was issued on 16/12/2017. Registry of the received relevant records from the foreigner tribunal court Valpara. Petitioner is already in interim protection in bail in 16/12/2017. Rule. This matter for hearing. To appear before Supreme Police Court of Valpara on or before 21st. Capturing hard.
21st, my lord.
21st of June.
Okay.
Notice in this case was issued on 16/12/2017. This is the records from finance tribunal. That's it. Interim protection, interim bail, 16/12. Rule hearing. To appear before the Supreme Police Court of Ohio on or before 21st. Capturing hard. Notice in this case was issued on 4/4/2018. Registry already received the relevant records from foreigners tribunal or better 10. Patasar Kusil be in the Vishanachari, sorry, Bojali. Or
Now I
in,
think, my lord, new district has been created. Huh? Bhadala district, na?
Yes. Okay. The and the registration retained as petitioner interim protection interim bail since 4/4/2018. Rule
Bhadala
hearing
district. Bhadala
to
district.
appear before the Superintendent of Police Border Bojali on or before 21st for capturing her Butterfly.
But in this case, this is not something not unique. But petitioner has been declared Indian by the tribunal. Despite that, his name has been put in the D voter list. Lordship will find the order passed by the tribunal at page 39. Page 39, the order. Foreign Tribunal Kokazar. Operative part will find the original one, page 40. Last paragraph order, page 40. Now, Lordship, and let's see page 52, the impugned order.
Yes.
By the ERO. Page 52. Serial number 1, Chandan Saha, so and so. And subsequently, his name deleted from the voter list. Page 52.
Yes, Ms. Verma, go to the records. We'll take it some on some other day. Tell us. Notice in this case was issued on 12/12/2019. Registry already received the relevant records from the Finance Tribunal for present. Petitioner is already interim. What is the interim? There is nothing. Interim protection since 18/4/2018. List on.
They will.
11th for admission.
Obliged, Lord. 11.
It will
Look
not
at the
come by the-
records. Notice in this case was issued on
Please, your lordship.
9/9/2019. Registry also received the relevant records from the Finance Tribunal. Number 2, Kamrup Metropolitan. Petitioner is already interim protection and interim bail. Pursuant to the order dated
11/6 for
2012,
admission.
2018 and 09/09/2018. Respective. Issue rule, place this matter for hearing. And take it fixed by the registry. Already biometric biometrics are saying.
Pleasure.
Notice in this case was issued on 01/03/2019. Registry already received the relevant records from the Finance Tribunal number 1 Modiga. That was called for by order. Same shall be retained until further order. Petitioner are already on interim protection. Sorry, interim protection. Since 21/12/2008. On perusal of the records of the case, we have seen that reference was made only with regard to the petition number. Ms. Verma,
Yes, your lordship.
the reference clearly reflects that it is against which one protection of Biswas.
Yes, lordship.
And the proceeding, the direction inquiry was against protection of Biswas.
Mhm.
Reference was against protection of Biswas. But the tribunal issued notice not only to the protection of Biswas, but all to others. So
Not mentioned.
that's how it is proceeded. In the meanwhile, protection of Biswas expired. The orders passed against the petitioners will be. subject. Brother will pass the order.
Just push for that. All things will be discussed faster.
No representation on behalf of the petitioner on call. So names of three councils have been reflected in the cause list. The registry has already received the relevant records from the Fairness Tribunal number 8 to brief. The petitioner is also on interim protection since 21/12/2015, list on 6th. For admission. He, Dharma. Melbourne.
Forty-one.
Notice and dispatch was issued on 15/5/2019. Registry already received the relevant records from the Foreigners Tribunal Kamrup Metro number of Guwahati that was possible by order dated 04/01/2019. Since 4/1/2019, the petitioner is also an interim. Others, interim protection. Hey, Harry record. Registry salary. Yes. This is a similar matter. Earlier we have approved of
Item 41, Lordship.
that earlier the proceeding was dropped.
Lordship may fix it up in the month of June, Lordship.
Hmm?
Proceeding drop which is high on records.
Okay, next, tickets. Shurul. Let's this matter for. As the petitioner has been declared to be a foreigner by the Learned Foreigners Tribunal Kamrup Metro for second Guwahati. By the order dated 06/07/2018, passing at case number 576 of the Shall appear before the Supreme Police Court. Sorry, Deputy Commissioner of Police Court. On or before 19. Right.
Yeah, happy to let her have check out. Nothing like that.
No representation on behalf of the petitioner on call. No names of five councils have been reflected in the court. Notice in this case was issued on 26/04/2019. Registry also received the relevant records from the Foreigners Tribunal Court, Valparaiso. That was called for by 4/1/2019. To retain record. Petitioner is also interim protection since 4/1/2019. And on interim date since 26/4/2019. List of sixth. Okay. Number के साथ.
Please, the appeal is against an order by the learned single judge, by which the prayer for interim relief has been refused. Now, the factual matrix of the case is like this, there is an advertisement by the respondent BPCL for appointment of dealership, petroleum dealership. Now, in the brochure that has been issued to the intending applicants, there are eligibility criteria prescribed. And one of the criteria is that with regard to filing of a lease deed, filing of lease deed for the site where the petroleum outlet will be established. Now, in the eligibility criteria, there are several clauses, namely clause 4, 6A, 6B, and 6M. These are the three clauses, my lord, which are primarily calling for consideration in the writ petition. Because an interpretation of these clauses will determine whether or not the appellant will be entitled to a consideration of his candidature. Now, the Honorable Single Judge has accepted the writ petition for the purpose of examining these clauses, but at the same time has refused to grant any interim order of interim protection. Now, if the selection is done and completed without there
Let us see
being
the advertisement.
advertisement, your lordship will find it page 42.
What are the requirements? Yes, Mr.
Now,
Bottom.
clause 4, your lordship will come to clause 4, that is at page 49. It starts at page 49, but the relevant part will be at page 50.
Land.
Yes. Now, if the land is to be offered by the candidate, he can either offer a land which belongs to him, or he can offer a family land, or he can also offer a land which he might have taken on lease from somebody. Now, if he takes the land on lease from somebody, then there is a requirement that the lease deed must also include the name of the original owner. And there is also an additional requirement. There is the requirement that there has to be declaration from the original owner that he does not have any objection if the BPCL utilizes the land for the purpose of settlement of the distributorship. Now, these conditions, my lord, to certain extent, my lord, that is the case of the appellant before your lordship, or also the writ petitioner, that to certain extent, my lord, there are some confusion with regard to the interpretation of these clauses. Because at one point of time, the clauses say that this has to be done at the time of filing of the application itself. Whereas, my lord, the reading of the other clauses also gives an impression that it can be cured within a period of 90 days. So to say that if there is some omission or commission in the filing of the application form, then this will be a curable defect. Now, whether or not this will be a curable defect in the light of the various clauses that are appearing in clause 6, 4(6), that is the issue that calls for consideration in the writ petition. Therefore, my lord, my humble and respectful submission before your lordships is this, that if the honorable court has decided to examine the applicability of the clauses vis-a-vis the claim of the petitioner, and at the same time, if there is no interim protection granted, then the entire writ petition itself will become infructuous. In fact, my lord, as on today, my lord, there is an interim order granted by your lordships, my lord.
Only 2 months. Well, yes, Mr. Bottaku,
Now, Madam, kindly see,
whether this, what Mr. Doctor is saying, that these are curable defects?
no, madam, it's not a curable defect,
Why,
madam.
why?
Why? It is not my executed by the co-owners, my lord. Release the matter. Our rejection, my lord, kindly see.
No, we understood that in certain cases, it has to be by the owners of the.
But there is a difference between applicant and lessor, my lord.
Hmm.
All the co-owners but did not execute the lease deed, my lord. Only one lessor, my lord.
According to
That is the
Mr.
requirement, my lord.
What Mr. Doctor is saying that these are curable defects.
No, my lord, this is incorrect, my lord.
Why it is not a curable?
Now, my kindly see, my lord. Page 50, my lord.
Yes.
Land, my lord. Clause 6, my lord.
Hmm.
The petitioner comes under group 1, my lord.
Hmm.
The applicant would be classified into 3 groups as mentioned below based on the land offered or land not offered by them in the application form. Group 1 applicant having, and the word applicants having suitable piece of land in the advertised location or area either by ownership long-term lease for a period of 19 years, 11 months or as advertised by the OMC. Group 2, applicant having farm offer for a suitable piece of land for the purchase or long-term lease for a period of 19 years, 11 months or advertised by OMC. Group 3, applicant who have not offered land in the application only applicable for location advertised under SC or SC category. Application under group 3 would be proceed advertised advised to offer land only in case no eligible applicant is found or no applicant gets selected under group 1 and group 2. Now, this is important. In case the land offered by all the candidates group 1 group 2 is found not suitable or not meeting requirements, then these applicants under group 1 group 2 along with the applicants under group 3 who did not offer land along with the application would be advised by the OMC to provide suitable land in the advertised location /states within a period of 90 days from the date of issuance of intimation letter to them through SMS/email. So in group 1, suppose there are 3 candidates in group 1, my lord.
Yes.
And the first applicant, my lord, got rejected. Then draw loss would be conducted within 2, my lord, 1 and 2, my lord. And if they don't qualify, then it comes to my lord, group 2, my lord. And if nobody is selecting group 1, group 2, my lord, then it comes to group 3, my lord. Then period of 90 days come, my lord, under this clause, my lord, in case of land, my lord.
But group 3 will be applicable only for the SC/ST category.
Yes, my lord. Yes, my lord.
This will be only for if the land is under, the location is under SC/ST.
Yes, my lord.
Let us assume it's a reserved land for SC/ST.
Yes, my lord.
Now, where is the
Now,
location here?
in the present case, my lord, there are 3 numbers coming in group 1, my lord.
Location is where?
Location, my lord, kindly see the application, my lord.
Location is Bogijan, my lord.
123, my lord.
Bogijan, page 45, your lordship will find the
Page 123, my lord. Clause 7, type of site DC. This is a dealer on site, my lord. Type of retail outlet, real. Group of the applicant on the basis of the land being offered, group 1. And when the advertisement, my lord, indicates that if there is confusion, he may contact with our officials, my lord. Now they have taken a plea that there is a confusion with regard to 2 clauses, my lord. My lord, kindly see the advertisement, my lord. We have categorically indicated in the advertisement. But they have annexed in page 43, my lord, but it is not readable, my lord.
No, the typed copy is given, my lord. The typed copy is
The
there.
relevant portion was not typed, my lord.
Yes, yes.
No, no,
Page
last-
45. You see page 45.
no, no.
Huh?
For
Mr. Bhattakur, where you are pointing out?
which one, my lord?
Copy
You
diya
have
nahi
seen the
log.
advertisement.
Page 43, my lord.
ऐसे नहीं बोले copy तो
Yes.
My lord, a column, my lord, for purchase, my lord, it can't be readable, my lord. That's why, my lord, I am giving the, my lord, readable copy, my lord. If there is confusion, my lord, with regard to any clauses, my lord,
ये तो type copy दिया नहीं yes
they may contact with our officers, my lord. And the advertisement categorically is said, my lord, that before submitting the online application, they should go to the brochure carefully, my lord.
A2 रे copy दिस A2 आसे तो page 42 से तो copy दिया था ये जे
No, no, it is not going
Hmm?
to. Now, my lord, kindly see their representation, my lord, against the rejection order, my lord, page 133. What is the reply, my lord, against the rejection order, my lord? In para 3, my lord, did the contents of the guideline clause 4 surplus 6A and contents of the appendix 3 seems to be confusing for us. If there had been, my lord, any confusion, they will certainly, my lord, contact with our officials, my lord, before submitting the online application. And appendix 3, my lord, which will applicable, my lord, in respect of us family members, it's not, it speaks about a lesser, my lord.
Now this- Where is why the reason for rejection?
Yes, my lord. Page, my lord, 131, my lord. In bottom, my lord, all corners. I'll probably rise, my lord.
Tell us still.
All corners of the offered land not executed lease deed and as per the guidelines mentioned in the brochure on selection of dealers for regular rural retail outlet 2023, clause 4, 6A, such lease deed is treated as invalid. What is say, my lord? It is in page 50, my lord.
Now where is the land document?
Land document, my lord, page 139.
One 139 is the lease deed, my lord, and there is a requirement of submitting affidavits that is at page 153.
No, my lord.
Mr. Rath will come to you.
Yes.
Let us see their objection.
Yes, sir.
But this lease deed is executed by, my lord, one, my lord, Surojit Gogoi.
The applicant.
No, my lord. He is a lesser, my
Prakash
lord.
Pupon is the applicant.
Yes, sir. Prakash Pupon is the applicant, my lord. Now, in page 41, I'll see, my lord, where the lessor is the absolute owner of a plot of land measuring 3 kata covered by so and so. And so and so. And second, my lord, and whereas the lessor is the being approached by the lessee for a lease of the said land for a term 20 years, commencing on and from the date of execution of the deed of this deed and monthly and so and so. Now, in the affidavit, my lord, which they have submitted, it says, my lord, it is for 25 years. Now we'll come to page 50.
Repeat that page.
Yes, my lord. 164, my lord.
One.
64, my lord. I'm sorry, my lord. Look, kindly come to page 150. Sorry, my lord. 155, my lord.
Yes.
This is the affidavit, my lord, filed by the lessor, my lord. In 156, you can see that now, para 3, my lord. Now I intend to give or lease the aforesaid land for a period of 25 years. To Prakash Pukon Ejedaba so and so. And so, but the land is concerned, NOC is concerned, my lord. Okay, page 153. It is about 13/9/2023. Well, can you see purpose of use, my lord? For residential use only.
Where you are reading? Present in use is residential.
Yes, ma'am. Now, my lord, can you see page 135? 535 is just Jamabondi copy, my lord.
135,
my lord.
Yes.
My the vernacular portion, my lord, page 137, my lord.
Yes.
Now, can you see the Kotta number 37, dag number 315. Now, my this is a mutation order. In right hand column, my lord, it is said, my lord,
Serial number.
my is saw, my lord. Sita pass kora upo homatar 90 take hukumate dan dia hutaman 315 nং dagor 3 বিঘা 3 কথাত 1 নম্বৰ চৰত 7 নম্বৰ নামজাৰি হয়। Then my lord saw Sita pass কৰা চক্ৰবিক্ষাৰ সয়ঞ্চো তাৰিখৰ হুকুম মতে খৰিদা হুতে 315/31 দাগৰ 1 কথা মাটি 7 নম্বৰ লগত 8 নম্বৰ নামজাৰি হয়। Then my lord next page, 138. Sitat pass কৰা চক্ৰবিক্ষা মহোদয়ৰ 27/8/2007 তাৰিখৰ হুকুম মতে খৰিদা হুতে 315/31 দাগৰ মধ্যে 1 কথা 4 লুচা মাটিত 7 নম্বৰ লগত 9 নম্বৰ নামজাৰি হয়। Then my lord চক্ৰবিক্ষাৰ 29/23 তাৰিখৰ নামজাৰি নং সয়ঞ্চো হুকুম মতে 315 নং দাগৰ উত্তৰাধিকাৰী হুতে বিপিন গগৈ স্থলত সুৰজিত গগৈ আৰু শ্ৰীমতী অল্পনা গগৈ আৰু অৰূপ গগৈ নামত নামজাৰি কৰা হ'ল। Then my lord চক্ৰবিক্ষাৰ 15/9/23 তাৰিখৰ নামজাৰি হুকুম মতে 315 নং দাগৰ মাটি উত্তৰাধিকাৰী সূত্ৰে অৰূপ গগৈ চলত শ্ৰীমতী মমী গগৈ, শ্ৰী অৰিন্দম গগৈ and অনয়ন গগৈ নামত নামজাৰি কৰা হয়। In the name of the kindly see in page 137, the dog is having 3 biga 3 kotha, and after selling and purchasing it comes to 3 kotha 1 kotha 16 lesa Now in their pleadings they have stated that they are the owner of 3 biga 3 kotha কিমান আছিলে তেৰা কিমান আছিলে তাৰপিছত কিছুমান আছিলে নে Now, Kali, come to page 30 of the written matter.
Yes.
But this is their petition, that the petitioner beg to say that the petitioner has offered a plot of land measuring 0 biga 3 kotha 0 lesa out of 3 biga 3 kotha. But they doesn't have that this much of land If you calculate from the Jamabandi, it comes to 3 biga 1 kotha 16 lesa
Okay. The other owners of the land did not give any.
But they have given affidavit that is not the requirement, Now kindly come to page 50,
Okay, we'll come back at 2.
Yes, madam. The other condition with respect to the other condition with respect to offering of land as under clause A, the land should be available with the applicant as on the date of application and should have minimum lease of 19 years, 11 months as advertised by the respective oil company from the date or after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease and there are multiple owners, then the lease this should be executed by all co-owners of the offered plot. In case the lease deed is not executed by all co-owners, such lease deed shall be treated as invalid. But this clause was never been challenged by the petitioner, madam. If you go by to the Jamabandi copy, there are 5 numbers of co-owners, and they are having only 3 biga 1 kotha 14 lesa. Though they have asserted that they are having 3 biga 3 kotha. And who is part of the land he is possessing, the lessor is possessing, we don't know,
Okay.
Now, kindly see clause F. In addition to the above, as and when advised by the OMC, provisionally selected candidate under Group 1 should also be uploaded a copy of any of the following documents to establish the ownership of the land offered for dealership. The document must have been executed, registered, issued on or before the date of application, registered sale deed, registered gift deed, registered lease deed for a minimum period of 19 years, 11 months, advertised by the respective oil company. Now, Z is important, madam. Now, before that, madam, kindly come to the online application submitted by the petitioner, madam, page 123. Come to page 124, relevant portion. Clause 13, land details, Group 1, copy of proof of ownership of land would be required to be submitted as and when advised by the Bharat Petroleum Corporation. Name of the owner of the land leaseholder, Surajit Gogoi. My second is important, relationship with the applicant. No relationship. Now, my lord, clause 15, undertaking by the applicant. I am awarded eligibility for retail outlet dealership will be decided based on the information given in the application above. On verification by the oil company, Bharat Petroleum Corporation Limited, if it is found that the information given by me is incorrect, false, misrepresented, then my candidature will stand cancelled and I will be declared ineligible for the retail outlet dealership. Now, if you again, my lord, come to clause Z, page 51, is speak about the, my lord, applicant only, my lord, not the lessor, my lord. The land owned by the family members will also be considered as belonging to the applicant. Group 1 subject to producing the consent letter in the form of affidavit, appendix 3. Now, I will kindly come to appendix 3, page number 99. The very affidavit, the clause on establishment, I understand that as per the definition of family members of the offered land own category of selection dealer. The lessor is not a family member of the applicant, my lord.
Please say it again.
I understand that as per the definition, is per comma, my lord, family members for the offered land under own category for selection of dealer for regular and rural retail outlet comprise of self, spouse, father of the mother, including stepfather, stepmother, brother, sister, stepbrother, stepsister, son, daughter, stepson, stepdaughter, son-in-law, daughter-in-law, so and so. Then that I am a member of the family unit so and so as per definition of selection of dealer for regular and retail outlet who is applying for retail outlet dealership so and so under category so and so against the advertised appeared in so and so. Now, if we go by the clause Z, page 51, is speak about the applicant only, my lord.
Yes.
May I read the clause Z, my lord? The land owned by the family members will also be considered as belonging to the applicants. Group 1 subject to producing the consent in the form of affidavit, appendix 3 from the concerned family members. Such consent letter in the form of affidavit should have been tendered by the concerned family members on or before the date of application. Here, this simple affidavit has been shown by the other family member of the lessor, my lord. Not by the applicant, my lord. Now, who are the family members is defined in clause A, my lord.
So you want to show that those affidavits will not be of any use.
Yes, my lord. It's
Because
no use,
they
my lord.
doesn't bring to the family members.
Yes, my lord.
Okay.
Now, clause M, my lord, kindly see. Various situation of the ownership of defining own oblique farm offer as under self. No need to file any consent letter. Self with family, with members of the family or own exclusive by the family members. Consent letter in the form of affidavit from the members of the family, appendix 3. Then clause 3. Self with other owners. Family members with the other owners. Self with family members and other owners. Then also my consent letter would be submitted by the co-owner, my lord. Now, my lord, kindly come to page 69.
Now, self with other owners.
If self means the applicant, my lord. Self means my
Applicant.
applicant, my lord.
With other owners.
Yes, my lord.
Then
If the applicant along with the other co-owner having my land, my lord, in the same dark, my lord, then also they have to give the consent letter, my lord.
they have given in the form of affidavit.
No, my lord, this is not a from my lord. This is given by the my lord, family member of the lessor, my lord, not by the applicant family, my lord. Okay. But kindly come to page 54. Note 1, my lord.
No, self with other owners. 3,
If my lord applicant and the my lord other corner in the same dark my lord having the land my lord, then the other corner will also have to my lord give the consent letter my lord.
yes.
Page 54 my lord, kindly see my
Now
lord.
land owned by third party in part or full. Group 2.
This is group 2 my lord. We are in my lord group 1 my lord. Group 2 my lord is the agreement for my lord lease.
Yes, then.
Page 54 my lord. Own means having ownership by a registered sale deed, registered gift deed, etc., or title of the property or registered long lease as per individual OMC norms in the name of applicant or family members as defined 4.6 and 4.6 is above my lord. And the applicant has to fulfill this criteria, my lord. They have undertook that they will fulfill. Now, my lord, kindly see page 69.
Yes.
Is speak of advertisement, my lord. Para 4, my interested applicants should go to the browser carefully for filling up the application forms. So they should know before submitting the my lord, application. I mean, which portion of the land is my lord? They are he is possessing the land, or is possessing my
Where
lord.
you are reading? Page 69.
Page 69 my lord, top my lord, clause C my lord. 69 my lord.
69, which clause?
My lord, clause C my lord, in top my lord, advertisement. From interested applicant
Okay.
should go to the browser carefully for filling up their application forms.
Okay.
Now, this is also again my reiterated in page 80 my lord.
Yes.
Clause 1 my lord, general condition pertaining to advertisement. The applicant should carefully go to the browser before submitting the applicant. Now, my lord, clause 6, page 81. Applicants should provide only that information against various items of application for which they are in possession of supporting document in original as on the date of application. Failure to present this document in original at the time of verification would result in cancellation selection. Now, the affidavit shown by the other family member, kindly see the it is in page 165. This is start from 165. It is shown by one of the co-name Alpona Soika. And it says my appendix S. They use the appendix 3 minute. This is not the format minute. In page 166, the area of the land is also defined from the online application. In online application, the area was shown as 625 square meter. In the affidavit, it is shown that it 712.89 square meter. 167 is mommy Gogoi madam. It's from 165 to 171 madam. The family member lesser madam depend madam. Now madam, the এখন করেছিল এখন representative and come again page 133 their representation madam. Clause 1 well, that a lease deed was signed by the lessor on the basis of NOC offered by the co-owner attest enclosed.
You are reading where?
On the page 133 madam. This is a representation madam submitted by the petitioner madam. 9/2/2024 madam. That a lease deed was signed by the lessor on the basis of the NOC offered by the co-owner, that as per the appendix 3, all the co-owners along with the lessor has declared to lease the said plot of land if I am selected successfully so and so. That the contents of the guideline in clause 4 subclause 6A and contents of appendix 3 seems to be confusing for us. If they had any confusion, my lord, they have to clear, my lord, prior to submitting their application.
Yes.
Now they cannot, my lord, go again, my lord.
Okay.
Now, my lord, I'm relying the accused husband, my lord, the Supreme Court, my lord. Here is Sondra Studio. Sondra Studio 23. Tata Motors Studio.
Yes, you want to play something?
Yes, madam. Okay, I will do it.
What do you want to show from Tata Motors?
There are 48, madam. Here, madam, I have to see, madam, whether our action is nullified or if any will not be, madam. Because, madam, we have rejected, madam, his candidates are as per our guidelines, madam. Now, in para 40, from para 48, madam, 52 and 52, 53, 54, madam. May I read, madam?
Please.
This court, being the guardian of the fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malafide, any bias. However, this court has cautioned time and again that the court should exercise a lot of restraint while exercising their powers of judicial review in contextual or commercial matters. This court is normally loath to interfere in a contextual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertaking compete with the private industry. The context entered into between the private parties are not subject to scrutiny under re-jurisdiction. No doubt the bodies which are stated within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to the re-jurisdiction of Superior Court. But this discretionary power must be exercised with great deal of restraint and caution. The court must realize their limitation and the havoc which needless interfere in the commercial matters can cause. In context involving technical issue, the court should be even more reluctant because most of us in Judges Europe don't have the necessary expertise to adjudicate upon a technical issue beyond their domain. The court should not use as a magnifying glass while scanning the tenders and make every small mistake appears like a big blunder. In fact, court must give a fair play in the joint to the government and public sector undertaking in the matters of contract. So, the petitioner has to give a clear-cut case of malifiedness, arbitrariness, about our action. Kindly see para 53, para 53 and 54, my lord. And 52, my lord, speaks about, my lord, the phase tender, my lord. If it is allowed, my lord, it's a time consuming and, my lord, it causes a, my lord, financial constraint to the public undertaking, my lord. Para 53, the law relating to award of contract by the state and public sector corporation was reviewed in so and so, and it was held that the award of contract, whether by a private party or by the state, is essentially a commercial transaction. It can choose its own method to arrive at a decision, and it's free to grant any relaxation for bona fide reasons. If a tender documents furnish such a relaxation, it was further held that the state, its corporation, instrumentalities, and agency have public duty to be fair to all concerned, even when some defect is found in the decision-making process. The court must exercise discretionary power under 226 with great caution and should exercise it only in furtherance of public interest, not merely on the making out a legal point. The court should always keep the larger public interest in the mind in order to decide whether its intervention is called for or not. Only when it comes to the conclusion that the overwhelming public interest requires interference, the court should interfere. But there is no pleading in the petition, my lord, that public interest is, my lord, defeated, my lord. Para 54, as observed by this court in so and so, while invoking power of judicial review in the matters as to tender or award of contract, certain special features should be borne in mind that the evaluation of tender and the award of contract are essentially commercial function and principle of equity and natural justice state the dissent in such matters. If the decision relating to award of contract is bona fide in any is public interest, court will not interfere by exercising the power of judicial review, even if the procedural aberration or error assessment or prejudice to a tender is made out. Power of judicial review will not be invoked to protect private interests at the cost of public interest or to decide contextual dispute. Introduction. Here, the issue was that the petitioner was selected, and subsequently he is on the basis of leased in registered leased, and thereafter it was surrendered. Whether it was lawful or not, ultimately the petitioner candidature was rejected. Then he come to the High Court of Allahabad. Now, you come to para 32. But this is the submission of the respondent. Mary, the factual part is from 2 to 11.
Yes, read.
Para 32. The third argument advanced by the Learned Council appearing on behalf of the corporation is that it is well within the rights of the corporation to determine whether a land is suitable or not for the purpose of setting up a retail outlet of the petroleum product. He submitted though dealership offered by the respondent corporation is on the basis of the owner own dealership retail outlet in the present case, but the corporation would be the best judge to determine that the particular land is a suitable land for the purpose of investment. He submitted the investment is long drawn one and therefore it has to be secured one. He submitted that merely because the land is as per the measurement and located at the site itself would not make it suitable in every sense of word. Meaning thereby he argues, if the document the land creates an impression of any likelihood of civil litigation relating to right and title of the land property, the corporation would be justified in not treating such land to be suitable land. Thus, according to him, merely because the lessor and the original lease have not questioned the title, it should hardly be the matter, as in the case if the documents relating to the lease or title of the land are such that they make it questionable in court of law at the future point of time, resulting in long-run civil litigation. It is para 33. it is argued that corporation may be a public sector corporation, but if it is long business, then it is a base just to ensure the business prospect. Merely because an advertisement has been issued inviting application and one is selected in draw of loss would not create any indefeasible right in his favor to claim for allotment of dealership as a rule. Now, kindly come to my para 72, my lord.
Yes, Mr.
Yes, ma'am. So far as the other question regarding the discussion of the corporation, we are of the view that the corporation is in the best position to decide which land suits to its business prospect, and the discussion exercise in this regard has to be seen only from the view that the corporation would be interested in providing its investment only in the safe and secured land. If the corporation has found that the document pertaining to the land are not absolutely clean in the sense that there exists chance of litigation in future acquire the land in which the investment is to be made, the corporation is the best position to understand to take decision as to whether the investment should be made or not over the land. So the suitability of the land lies within the domain and discretion of the corporation. Paragraph 74. An exercise of evaluation and decision making is a subject of judicial review. In the event of an action is vitiated with bias, malafide, and in violation of principle of natural justice, even evaluation of the credential, if vitiated for utter ignorance of law or by the whimsical action, would invite interference, but where a document becomes a matter of contentious issue and involve complicated question of fact what the title needs to adjudication by the civil court for its valid declaration, as involving valuable rights and parties, corporation as a third party would be justified in keeping its hands off. Case in hand has the element to invite long-run civil litigation in the future. So if corporation decide to term such land as not suitable, we don't find any fault with the corporation.
Okay.
Now, here's see, the corporation is the author of the document, my lord. 2025 is the My is meant 2022 5 SCC.
Just a minute. Yes, Mr. Voter.
Yes, madam. My is meant 2022 5 SCC. Page 362, madam.
Okay, please repeat.
I have given a book list. My is Ag Metal India Private Limited. 362.
Which one? 2022 5 SCC?
Yes, madam.
Yes.
My is
11 paras,
para 24 to 26, madam.
24 and 26.
Yes, madam. 24 to 26, madam.
Just tell us the position there.
My says, my lord, because the corporation is a base person, my lord, to understand its requirement, my lord. Until unless, my lord, if there is a malafide or arbitrariness, my lord.
Employer's decision.
Yes, my lord.
Okay. Then.
Because they cannot compel us to accept their views, my lord. What they think, my lord.
Okay.
Then, my lord, next one is my lord, 2016 8 SCC 622, my lord.
2020 or 2016?
2016 8 SCC page 622, my lord. Well, I have given a copy, my lord.
2016
8 SCC
page
622, my lord.
What do you want to show from
My is whether, my lord, the terms are essential or mandatory, my lord. It has to be seen, my lord, from the view taken by the corporation, my lord.
Okay, 11 paragraphs, 38, 43, 48.
Yes, my lord.
What else?
It says, my lord, it cannot be, my lord. For a moment, can listen. He says that we cannot deviate from our own terms, my lord.
Okay,
Here, but the cases there, my lord, the EMD was to be submitted in a particular format, my lord. When the petitioner, my lord, did not submit in a particular format, my lord, it was rejected, my lord. Then I come to the court, my lord. The court said that, my lord, that it is an essential condition, my lord. It has to be seen, my lord, as per the view
That's
taken
right.
by the
right.
corporation, my lord.
What else?
Out of the one, cattle rate, cattle rate. Otherwise, one is, my lord, 2019-14 SSC page 81.
You
my lord.
need to have to show all these.
Yes, my lord, the para 36 is very important, my lord.
Which one?
But it cannot be seen, my lord, as a by a way of magnifying glass,
Of
my lord.
which one?
My lord, the KRTL Import and Limited, my lord, the 1914 SSC page 81, my lord.
19 citation.
Yes, my lord. The 1914 SSC page 81. This para is from para 37 to 39. my lord.
Which para?
37, 38, and 39. my lord.
Yes.
In para 37, my lord, would see, my lord, one minute sentence is used, my lord, and unnecessary clause is could be of minus detail constitute a view of a tender authority makes awarded contact by government and public sector is a cucumberance of exercise with long drawn in our out litigation at the
Okay.
threshold.
Then
Then my Silpi construction, my lord, 2020
16
SSC. Page, my lord, 489. Para 16 to 20, my lord.
Do you need to show all these? Only one is your sufficient. Okay. See, basically, Mr. Doctor's case is that he said that there are certain clauses where 90 days time given. So that's how he said it's confusing for that purpose. So if we such fault,
That will come later on, my lord. If all the candidates of group one fails to qualify, then is come to my lord, group 2, my lord. Then 90 days will come, my lord, along with my lord, group 3, my lord.
so here according to
Clause 6, my lord. Page 50, my lord. In case the offered land offered by all the applicants of group 1 and group 2 is found not suitable, not meeting the requirement, then these applicant under the group 1 and group 2 along with the applicant, the group 3 who did not offer land along with the application would be advised by the OMC to provide suitable land in the advertised location of the states within a period of 90 days from the date of issuance of intimation to them through SMS. If the candidate my lord fails to qualify in group 1, then it comes to my lord group 2. If the group 2 fails, then it group 3, my lord. Then the 90 days would come, my lord. Suppose my lord, the applicant is having his own land, my lord, and he is having my lord other co-owner, my lord. Then 21 days is given, my lord, to rectify the defects, my lord. He is confusing the word, my lord, the self, my lord. Self denotes, my lord, the applicant himself. It will 21 days to.
No, page 10, not 3.
No, over 21 days is concerned, that will find in page 55, note 3, my lord.
Okay.
That's why I'm submitting, my lord, before submitting the application. He should go through the application, the brochure carefully, my lord. Because it is a commercial transaction, my lord.
Okay. Let us hear Mr.
If we my lord, relax, my lord, it will be relaxed for all others, my lord.
Yes, Mr. Doctor.
Lord, I would like to draw attention. Of course, my lord, my learned friend has extensively dealt with all the conditions, my lord. But my primary plank of argument is that whatever has been
See,
prescribed
basically, we are with regard to the order of the learned single judge.
Yes.
Now, see, you have given the land from a particular lesser.
Yes.
Now, that land has joint owners.
Yes.
The particular lesser is not the only owner. He has other co-owners on that part of the land.
Yes.
And as per the requirement has been pointed out by Mr. Potrakur from the advertisement itself, the brochure itself, all the terms and conditions for that dealership. Now, it has to be given by the all. The agreement should be given by all, not by only particular lesser. Here is a case what we have done, only one person has given, and the other persons have given their affidavit.
Yes.
Will that suffice the terms and conditions of the process?
Exactly. That is the question. Now, my lord, my submission is this: the honorable single judge has kept the writ petition pending to decide the matter upon examination of all the clauses. Now, if the matter remains pending before the honorable court, and at the same time some interim protection is not given to me, in that case, the writ petition itself becomes infructuous. Because if they go ahead with the selection process, and in my place, because I came out the first candidate in this select list that was drawn, I came out to be the first candidate. Now, if the selection is carried on while the writ petition remains pending for examination of these clauses, my lord, then the petition becomes infructuous. Therefore, and the amount of argument and volume of references that have been made from the respondent side, well, that itself is an indication of the fact that the matter requires a thorough examination.
No, since there has been, this court has passed and stay. That is the
Yes.
reason, probably. Otherwise, I don't think. So, what they try to bring the judicial authorities, they are being the employer.
Now,
So
judicial authorities, my lord, with all respect, my lord, I will submit the citations that have been placed before your lordship. These are all in the realm of award of contract. Here is a matter which is entirely different from award of contract. It's a matter where appointment of a dealership is in question. In the realm of award of contract, my lord, it is absolutely with the employer.
Apparently, accepting one of the co-owners, there is no agreement with the other co-owners.
No, now that therefore, my lord, therefore, if I can
Show
show
us from where it is possible that you can cure that defect.
exactly. That
Which
is
provision shows that?
yes. Now, if your lordship will kindly therefore, my lord, at the beginning I said that the scheme of the conditions.
Did you challenge any of the clause?
No. This what I submitted.
Show us-
Yes, I'm
Take us to
just.
that particular provision which.
Yes,
gives
I am
you that
formulating that
time
point, my
for-
lord. In page 50, your lordship will notice that provision, my lord.
Yes.
I am formulating this point, my lord, that the scheme of the conditions, eligibility criteria, if read as a whole, my lord, it will indicate that it is not something very rigid. It's a flexible thing which permits the defects to be cured at a later point of time. Now, if the defects are
Yes,
permissibly.
Mr. Datta, kindly read and place it before the court, how
Yes.
it is curable.
If your lordship will kindly come to the second paragraph.
You read as a whole enter 6, it is better to understand. Read para 6 of the brochure.
Yes, page 50.
Hmm.
Now, page 50, the applicants would be classified into 3 groups as mentioned below based on the land offered or land not offered by them in the application form. Then comes group 1, and we are concerned with the group 1 only. They have classified us as group 1. Applicants having suitable piece of land in the advertised location.
That is the applicant itself is having the land.
Yes.
Then second part,
Applicant itself is having the land or applicant takes the land on lease. That
Okay.
will also come under group 1.
Hmm.
Now, second, group 2 and group 3 are not relevant for the
Yes,
purpose of this
yes.
case. Now, second paragraph, in case land offered by all the applicants under group 1 and group 2 is found not suitable, not meeting requirements, then these applicants under group 1 and group 2, along with the applicants under group 3, who did not offer land along with the application, would be advised by the OMCs to provide suitable land in the advertised location stretch within a period of 90 days from the date of issuance of the intimation letter to them through SMS mail. Now, there is a condition, my lord. I am just drawing your lordship's attention to the clause A down below. That other conditions which comes under the other conditions with respect to offering of land are as under.
now this particular proviso in
Now,
case.
Yes, my case is
That will be only when the cases of
1 and 2
applicants 1 and 2.
are considered and suitable
Yes.
land is not found.
Now, as on date, there are applications or there are applicants from group 1 or not.
Yes. Yes.
But this is only after the exhaustion of group 1 and group 2.
Yes. Therefore, my lord,
It's in Koyala.
my lord, I am trying to make one submission.
Hmm.
The idea is to appoint a dealership with reference to a particular plot of land.
Hmm.
And one of the very essential condition is that the applicant or the applicant's lessor must have a land within the specified area. That is an very essential condition. If I file an application and I don't offer the land, my lord, then it is a redundant exercise. The second condition comes, which is hitting us. The second condition comes is that if we offer a land based on lease, then in respect of the land held by several persons, all the owners should join in the lease deed. That is the requirement. And that is where the applicant's, the writ petitioner's case has been hit. Now, if the first stage is taken into account, my lord, the first stage stipulates that in case the land itself is not suitable, somebody may have offered the land, but it is not found suitable according to the BPCL. Then this can be corrected within a period of 90 days. Of course, after completing list 1 and list 2, so to say, category 1 and category 2. So the very essential condition, which is of offering of land, that can also be corrected after a certain stage. If group 1 and group 2 both considered together comes out in the situation that the land is not available or land is not suitable, then BPCL reserves the right to give them 90 days of time to find out a suitable place of land. So the very essential condition, which is land, my lord, regardless of the ownership, which is suitability of the land, that is also flexible in a sense that I can rectify the mistake or rectify the defect within a period of 90 days. Now comes the second stage. Second stage is
where, my lord, the land is suitable, but the ownership issue is with regard to the lesser. And there are several lessers, there are several owners of the leasehold land. In that circumstance, my lord, the requirement is that the clause A says that all the persons who are the owners, they have to join in the lease deed. That is where my application, they say that since my lessers have not joined in the lease deed, so my application is not correct, or my application is liable to be rejected. That is the ground on which they have rejected. My submission is this, my lord, if the very essential condition can be, the rigor of meeting that condition can be relaxed for a period of 90 days, if the suitability is otherwise, then why not this? This is one limb of argument, my lord.
No,
This
whether,
secondly-
now whatever the terms and conditions are prescribed, that has to be as per the employer's decision.
Exactly, that has to
So-
be, now, the employer
If it is-
employer
You are
himself
saying
says,
that since there is a provision for curable defects giving 90 days time,
yes,
so in that circumstances, if the offering of the land, if it is a lease
yes,
and there are numbers of owners or more or co-owners are there,
yes,
that can also be cured
yes.
according to you.
Yes, yes.
But who will set the terms?
Now I am making this submission on the premise that the conditions which the application brochure has laid down, these are not very rigid, these are flexible.
Where from you are saying?
That otherwise this period of 90 days would not have been given. If you are giving a relaxation in terms of in respect of a criteria which goes to the root of the matter, then the subsequent thing, then such amount of rigidity cannot be experienced. This is one aspect of the matter, my lord. The second limb of argument is this, my lord. Now, the application brochure also lays down a condition that there has to be affidavits from co-owners. We have, admittedly, my lord, we have submitted affidavits. All the owners did not join in the lease deed, but we have submitted affidavits. Now, whether that will suffice the requirement, as it has fallen from your lordship, my lord, whether that will suffice the requirement of submitting a complete application.
What of,
Now,
whether
yes.
that has been laid down by the BPCL, the employer.
Yes, your lordship will kindly come to page 52, my lord.
Hmm.
Sorry, 51, last
Yes.
clause G. My learned friend has read it to your lordship.
Hmm.
Clause G. The land owned by family members will also be considered as belonging to the applicant.
Hmm.
Subject to the producing the consent letter in the form of affidavit appendix 3, which admittedly we have given
Hmm.
from the concerned family member. Such consent letter in the form of affidavit should have been tendered by the concerned family members on or before the date of application.
Hmm.
Now, if I am offering a lease deed or the consent letter, then also the requirement is that it has to be before the date of application. The consent letter or the lease deed has to be before the date of application. Now, clause H, for the purpose, family members should comprise of self, that is the applicant himself, spouse, and other members.
Hmm.
Now, clause M is very crucial. Clause M says various situations of ownership for defining owned farm offer are as under.
Hmm.
If your lordship will take the serial number 2, self with other members of family or owned exclusively by family members. In that case, my lord, there is a requirement of submitting consent letter in the form of appendix 3. Our case is that, my lord, we fall under this category. We fall under this category, and therefore it will suffice the requirement of submitting the valid documents. Why we say that we fall under this? The answer will be, my lord, at page 54, note 1. Page 54, note 1. May I read it, my lord?
Yes.
Note 1 says own.
Hmm.
Own means having ownership by way of registered sale deed. See, if I am the owner by virtue of registered sale deed, registered gift deed, etc., or title of the property or registered long lease. Now, if I have the lease deed in my favor, then also I am owner.
Hmm.
So here, admittedly, my lord, I have a lease deed.
Hmm.
Therefore, since I have a lease deed, then I come under the expression of owner. Now, if I'm coming under the expression of owner, then this clause M, serial number 2 gets attracted. That self with other members of family owners. If this gets attracted, then the requirement is that the other family members should only submit the consent letter, which admittedly has been fulfilled. So this is also an alternative situation, my lord, which operates as against what your lordships have noticed at page 50. Page 50 clause A says that if I am submitting a lease deed, then all the owners should join. But this clause also says that if the ownership is on the basis of a lease deed, because if I have a lease deed in my favor, then it will be deemed to be a ownership in my favor. Now, if I am having a ownership through by way of leave, in that case, this clause gets attracted, and it is not their case that the affidavits which have been filed, right from page 153 to 163, all the members of the family of the lessor have filed the affidavit saying that they don't have any objection if the land is offered for setting up a petroleum outlet. Huh? So this is the case of the appellant, that he satisfies the condition, my lord, because of clause M, and the meaning that has been given by the note 1, own, that will bring him within the expression of owner. And although my learned friend has referred to the area of the land, my lord, that it is 625 square meter, whereas but area of the land has not been a question on which my application has been rejected. And otherwise also, the land offered by me is more in the, in terms of dimension than what is required. The required dimension is 625 square meter. The land I have offered is 700 something square. 729 or. Come on. 729 square meter in respect of particular person. So therefore, otherwise also, that is not a ground on which my application has been rejected. My application has been rejected on the ground that the lesser family members have not joined in the lease deed. And in my representation also, I have said that these two clauses, if read together, my lord, then it creates confusion. Because on the one hand, you are saying that everyone has to join, and on the other hand, you are qualifying that if it is from the family member, then affidavit will suffice. So, viewed in this respect, my lord, my humble submission is that if these clauses really requires an examination for the purpose of ascertaining whether or not my application meets the test of requirement, then in that case, there has to be an interim order in my favor. Because that is a prima facie case. And the Honorable Single Judge has also kept the matter pending for the purpose of examining these issues, calling them to file their affidavits, which they have not done till date. Till date, my lord, the respondents have not filed their affidavits in the writ petition. When was the order of the writ petition?
Anything else?
Well, that is all. One thing only, page 55, note 3, your lordship may see.
Yes.
Note 3, clause 1. In case after selection, if it is observed that the offered land is co-owned by multiple persons, and the provisionally selected candidate did not provide consent of all the co-owners, and provisionally selected candidate would be given 21 days of time to get consent of all the owners. Had it been a case that I did not submit consent from all the other co-owners, in that case also, my lord, after my provisional selection, I am getting a time of 21 days to rectify this mistake. So therefore, if all the clauses of the document are looked into, my lord, it projects a scheme where there can be curable defects, and curable defects can be cured at any point of time. But they have given a time limit for certain things, 90 days, for certain things, 21 days. So it cannot be understood to be a very rigid setup of the regulatory form of conditions that in case I don't find it, don't do it at the time of filing of the application, my doors are closed. Huh? That is my case. Therefore, my humble and respectful submission would be, my lord, your lordship may examine this matter in this bench also, or your lordship may.
Yes, Mr. Bhattacharya,
I
just
want to kindly
reply
say the in clause 6, my lord, the word applicant is used by applicants, my lord. It's in a plural form, my lord, not in a singular form, my lord.
that we have seen.
And suitable of the land, my lord, it comes later, my lord. First, his document has to be verified in, my lord, the application scrutiny committee. Then, my lord, the LEC will come, my lord, that will find, my lord, page 73. Then field verification cadency route. Then only my LOI has been issued, my lord. And that will clarify from my lord, redraw, my lord, the clause, my lord.
My lord, this is elementary English, my lord, with all humbleness I will submit. Since it is the paragraph is referring to group 1, 2, and 3, naturally it has to be in plural. It cannot be in singular. The opening paragraph, opening sentence refers to all the 3 groups. So naturally the plural version of the applicant has to be employed. It cannot be in a singular form. This is
But there are
elementary
3
English.
candidates in group 1, my lord. All have to, my lord, disqualify in the group 1, my lord. They will come to group 2, my lord.
Then whether why that page 55 note 3 is required.
This
This is meant for whom?
for applicants himself, my lord. Is consent of the family members, my lord.
Kindly read note. Kindly read note.
Yes, my lord. In case after selection, if it is observed that the offered is owned by the multiple persons, then the provisionally selected candidate did not provide the consent letter of all co-owners. The provisionally selected candidate would be given 21 days time to get the consent of all co-owners for offered land failing which the candidature of the provisionally will get rejected. However, for the location advertised under so and so is not required. Then 2, my lord. You can clarify from 2, my lord. Consent letter in the form of appendix 3. Appendix 3 speaks about, my lord, family member, my lord, of the self applicant, my lord.
No.
Not, it does not delineate, my lord, lesser, my lord. If you go by the, my lord, clause M, my lord.
You want to say that clause 1 is followed by clause 2?
Yes, my lord. Because the consent letter is to be submitted in the form of appendix 3, my lord. Appendix 6 denotes, my lord, the consent letter from the self family member, my lord. If you are having a land, my lord, with the co-owner, my lord. And number the affidavit, my lord, which they given, my lord, from 155 to 161, my lord. It was submitted, my lord, before the deputy commissioner for getting the NOC.
No.
It was yesterday in the para 14, my lord.
Your lordship can just verify it from the affidavit. The bare comparison of page 99 along with the affidavit at page 153 will make it clear. He is reading only the first part of the page 99, not the part coming below the word or. It's a
From
detailed-
155 to 164,
it's a
this
detailed
affidavit has been
format.
filed before the deputy commissioner as per their pleadings. Para 14. And from, my lord, page 165 to 173 or 171. They tried to give it a color as appendix 3. Appendix 6, my lord, speaks about the consent letter given by the family member of the applicant himself, my lord. If he offered his own land, my lord.
Come to read page 99 top.
99, my lord.
That's the appendix C, right?
Yes.
So
After the first paragraph or, the portion below the word or.
read at the top, notarized affidavit.
For offer of land from the family members and a third party support. A third party is, my lord, clause M, it is defined, my lord. If the applicants, my lord, if he offered his own land, my lord, and if there is several co-owners with him, my lord, then the other co-owners, my lord, of the dark number, my lord, he has to give a consent letter.
Those are third party.
Yes, my lord.
Hmm.
It is clear from the clause M, my lord.
Hmm.
His neighbor speaks about my lesser, my lord. That's why I'm saying, if they are so confused, my lord, what prevented him, my lord, to get it clarified before submitting the application? If we relax, my lord, for him, we have to relax for all others, my lord. That's why I mean, in my lord, the Airtel Infotech, my the Supreme Court said, my lord, they cannot compel us to accept their views, my lord.
Well, we are not compelling him to accept our views. We are only asking for a
And what
clarification.
portion of the land, my lord, he is possessing, that is also not clear, my lord.
That is not the ground on which my application has been rejected.
Anything else, Mr. Doctor?
Well, I'll just show your lordship page 99, just below the word or.
Hmm.
Now, if your lordship will compare the affidavits that we have filed before them, my lord, it is exactly on this format. How do they say that it is not as per Appendix 3? And that is not the ground on which my application has been rejected.
Okay.
It has not been rejected on the ground that
These
my
are not-
affidavits are not in terms of Appendix 3. I'm just drawing your lordship's attention to page 161. So, I'm sorry, my lord. No. Format of
These are not used, my lord.
Page 170. Page 116 and 170, or just a bare eye perusal, open. Kindly see, my lord, this box which has been given in the page 99, that is exactly replicated in the affidavit.
Hmm.
Page 99 and 170, just a bare eye comparison. This is exactly in terms of Appendix 3.
Hmm.
So therefore, my lord, if the description of self is understood in the context of the note 1, then, my lord, I'll clearly come within the description of this. And I have given, and in any case, if they still think that there is a necessity of joining them as co-lessors in the lease deed, they can always be corrected. That can always be corrected, because the entire scheme of the selection process envisages granting of time at different stages of exercise. That's my humble submission. I could put this way, they have also 179 of natural, same.
Mr. Bhattakur,
Yes, my lord.
lesser will come under the category of third party or not?
No, my lord.
Where from you are saying?
It is not in the my lord, clause M, my lord.
Cause?
Clause M, my lord. Various situation of ownership of defined own, my lord.
Hmm.
It does not include, my lord, any third party, my lord.
Where is the third party? Then who is the third party?
As in view of the affidavit, my lord. This is their contention, my lord.
Then why this third party at page 99? Appendix 3. We are asking you, who is this
Yes,
third
yes.
party?
Top 99 page top.
But this is in respect of, my lord, group 2, my lord. The 14 seat will also not.
No, this is appendix 3.
Yes, my
right?
lord.
That is why you are asking you, who
Yes,
is
my lord.
this third party? Read the top
Yes, my lord.
notarized
And
affidavit.
that will, my lord,
offer of land from
Yes,
family
madam.
member.
I'll just.
Petitioner, the land is not offered by any family member.
Yes, madam.
Right?
I'll just pay payment.
Or third party
Yes, madam.
supported by land documents. Now, who is this third party? If the lessor is not third party, then who?
Hero driver. Group driver. Playback will play. Group driver. Group driver. Word on the. But page 53 madam. Group 2 madam. Land owned by third party in the part or full, consolidated in the form of affidavit, power of attorney from other owners, appendix 3 madam. This is a farm of is respect of group 2 madam.
Group 2. Land owned by
We are in group 1 madam.
But if that becomes the case, then where is the requirement of filing appendix 3 in page 52? Page 52 also says about the appendix 3. Last line. But
And a group 1 madam only say that the word self is used madam. The word self used madam. If the applicant himself offered his land madam. Because in the application madam, who is he submitted madam, online application, he says there is no relationship with the lessor madam.
Okay.
but they are saying everything, my lord, but without any focus on note 1. What is the meaning of note 1 that you are ascribing? Note 1 makes it very clear that I can own land by virtue of a lease deed also. And if I own the land by virtue of a lease deed, I become the owner.
Is it in the format?
나가네도. 이거 나가네도. 응, 거면 높아.
ST হলে কিভাবে থাকবে?
কোন এসপি না হয়? এসসিও না হয়। হ্যাঁ, এসসি হয়ে যাবে।
ভালো ya.
ডুবিলে লই যাও।
তোমাদের গ্রুপ বানালে গ্রুপ তোমার মধ্যে গ্রুপ
In 90 hole उसमें appendix खोल लिया एकदम the main ये second part to group 2 करना होगा group 1 करना है itu ya kan kan kayak itu for to group 1 करना है और second to group 2 करना है हाँ so the group 2 करना होगा কোনো group করে না
Mr. S. Dutta, London Senior Counsel. For the petitioner. Assisted by Mr. M. Doctor, counsel for the petition. And Mr. S. Thakur. Learned counsel for the Tarakote. And Mr. S. S. Ray. Roy. Learned CGC for the respondent number 1. Also heard Mr. S. Thakur. Learned counsel for the BPCL, respondent numbers 2, 3, 5.
No, 4 is meant by government.
2, 3, 5, not 4. No, sorry, 2, 3, and 5. And Mr. H.K. Hazari, get us some for the respondent.
But there is an interim order operating.
Order reserved, so necessarily.
That your lordship may observe that pending disposal of the status quo order will continue. That your one line your lordship may observe. Obliged.
Line to line. Pending interim order passed election remaining. Why for this orders?
My lord, in this case, there is an IA, my lord, for condonation of delay 1614.
Who is
In
appearing?
that case, my lord, I am appealing for the appellant, my lord. In that case, my lord, the honorable court granted us liberty to file an additional affidavit explaining the delay, my lord, particularly after the COVID-19, because the petitioner, as the respondent has taken a plea, the COVID-19 period, post COVID-19 period was not explained. And therefore, we have filed, my lord, giving all the note sheet, annexing all the note sheet, the steps that we have taken. My lord, delay is of 341 days. 41 days. Well, what happened? The judgment order was passed on 26/9/2019. Well, after and the London single judge, while giving the judgment, giving a direction to the respondents to make payment to the petitioner contractor, the dues which he had. Therefore, my lord, in terms of the judgment, initially within a period of 60 days, the direction was. Therefore, my lord, before filing an appeal, we thought it proper to comply with the direction, my lord, and given him all the payments. The petitioner received, my lord, 49,93,235, the amount due to him. But my lord, since
Reserving the right or without reserving the right?
we're reserving right, my lord, because we have given it, we're reserving right.
Where is that?
My lord, though you have not, but it is in the record. It's on the simultaneously we have filed, my lord, the appeal. There is an already, and my lord will kindly see after it happened.
After making the payments.
After making
At the time of making payments, have you intimated to the petitioner
my lord,
that you are making this payment in terms of but reserving the payment of preferring?
my lord, there is a note sheet. The lordship will find in the note
Have you
sheet.
intimated the petitioner, the respondent, the contractor? Yes.
Who?
Have you informed the contractor?
No, my lord.
In compliance of the order, you have done it. Fine.
No. What I have done is because since the London single judge interpreted various terms of the contract, which had, my lord, which had an adverse effect on the subsisting contracts, because we follow the terms of the contract throughout the country, my lord, uniformly. So, my lord, since it has an effect on existing contract and other contracts throughout the country, we thought it proper, my lord, to make payment first and then, my lord, take decision on the appeal. In the meantime, what happened, my lord, the COVID-19 had come. And therefore, my lord, there was none in office, my lord, to look into, to take a decision. Everybody was given the task of, my lord, ensuring proper food supply. For office staff also, there was none in office. After the COVID-19 period over, there was an audit objection, serious audit objection on this. And then, my lord, what happened? The authority taken a detailed, lordship will kindly take up the additional affidavit. There, everything is detailed, my lord. Additional affidavit, my lord, will kindly additional affidavit that will file. If lordship, I have explained in my affidavit, but then, Lord, I'll take up the relevant part of the note sheets, my lord, where the decisions are taken. Page 33, my lord, will kindly come. Yes. The additional affidavit, my lord. The petitioner would not be prejudiced because he has got the pen. The only thing is according to the only interpretation of the terms of the contract, which is, my lord, which remains to be decided by your lordship, because if it is, my lord, if we go by the interpretation given by the London single judge, then it will have an effect on all the existing.
So altogether delays of 341.
341, my lord, we calculated it 661, but the registry has calculated, my lord, that. it should be-
Definitely, because there is a notification.
Notification, and that's why, my lord, it's 361. We have explained for 661. Whatever, my lord. The lordship will kindly have a look at the page 33 of the additional affidavit. I'll just take your lordship to that. Page 33, my lord.
Hmm.
Well, Lord, I have explained in details in the affidavit, but I'll take your lordship to the note sheet, my lord, level, so that your lordship can be satisfied the steps that we have taken. But Lord, in 2019, we made the parent, there is a direction at the top. Then, my lord, in 2000, after the COVID, received the letter, my lord, your lordship got it in the middle, received the letter number so-and-so from dated 22 regarding CAG audit para. There is a serious audit objection on this in
Page
respect
number
of
33.
page 33 of the additional affidavit, my lord, that we have filed on 30th of November 2023.
Supplementary affidavit.
Supplementary affidavit.
You running page 33 or?
It's, I think it's, my lord, not running, running page 33. I've given pagination, my lord. Page 33.
No, up to 34 is your petition.
My lord, I think your lordship is taking the original application. My lord, the affidavit, additional affidavit that you have filed, my lord, on 30th of November.
That's where reading.
My lord,
Your internal page first tell us.
internal page 33, my lord. 33. Running page course. Lordship got it, my lord.
It's a note sheet.
Note sheet, my lord. I've given a type also, but then I'll read from the note sheet, my lord. At the top, my lord, the order in 2019, that was earlier order. Then when I received letter dated so-and-so from 29 dated 2022 from Dibrugarh regarding CAG audit para in respect of excess payment of transportation charges private respondents due to non-rounding of nearest so-and-so. The last para, my lord, will kindly see. Moreover, the DO Dibrugarh letter dated so-and-so states that in respect to Messrs. Ramota Trading, this is the petitioner, distance fixed by this office during the floating tender 7 km. But later on, district committee had decreased the said distance 5.2, stated in court case filed by the party, and the judgment, it was directed to fix the distance of 7 km. But CNG audit has read audit para, DOW requests to advise whether the NDC can be forwarded to RO Assam without dropping the said para. Now, my lord, kindly come to page 35. Page 35. My lord, I'll read the para 2. DO Dibrugarh, by letter dated so-and-so, 1905, had informed this office that distance as per the appointment letter was so-and-so. Accordingly, committee of DO level 7. Last para, lordship will kindly see. Last but one, para 5. This office in consultation with the Regional Finance Legal Division and FCA Standing Council so-and-so, dated so-and-so, Dibrugarh, to clear the outstanding bills of the concerned contractor per direction so-and-so, and DO Dibrugarh by letter dated so-and-so has informed this office that as per direction received from this office, area transportation bill of Ram Avatar had been released for total distance of so-and-so 5.3 km. The next page, my lord, kindly see. Next page, page 36, down below, a detailed clarification may be sought from DO Dibrugarh amount excess payment contract so-and-so. However, since the matter has financial implications, file may be endorsed to RO Finance Division for their opinion. Also, payment made to DO Dibrugarh was in compliance with the court's order. As such, file may be endorsed to RO Division so-and-so. Next, my lord, kindly come to page 38. 38, my lord, is handwritten. I have type copy also. I'll read from the middle, page 38. Further, the lordship got it further, page 38. With respect to the direction by the court, necessary opinion may be taken from legal division as suggested by the operation division as to whether the FCI should pay on the basis of 6.so km and FCI file appeal on the direction of the case to the higher court, or not, as the directions might have financial implications on all contracts where there is no weighbridge is located in the railhead and the trucks require plying some extra distance and so. Then, my lord, kindly come to at last, my lord, at page 43. Page 43, my lord. The note sheet goes on at page 43, my lord, serial number 10. There is a flow in the judgment as it is relevant whether mentioned in the committee respect that the total distance by the loaded trucks is 6.2 kilometers. Both the advocate's opinion that honorable court so-and-so standing guidance and so-and-so. Now, my lord, at last, next page, the approval is given at serial number 108. Serial number 108. If agrees, this is so-and-so. Ultimately, my lord, the opinion, etc., page 45, from page 35 onwards, opinion, etc., were taken, and the details were collected, and then, my lord, the case was filed. Therefore, this the period post-COVID is explained, my lord. We have taken detailed steps because it took some time for taking the decision on this matter. Because it has an effect. Because what happened, my lord, this standard clause which the learned single judge interpreted, as I said, my lord, this we are following throughout the country uniformly. So if we, my lord, take a different, my lord, stand here in this region, it will definitely have an effect. And there is a similar matter is pending before the division bench and review, my lord. In fact, the same was put to challenge. The division bench has given.
Yes, Mr. Chaudhary.
My lord, my humble submission is, though they have filed application twice, the delay has not been explained at all, my lord. And they are relying upon a judgment of the apex court where a period was shown that the limitation will not run during that period, my lord. But beyond that also, there are periods which have not been explained. Then your lordship has rightly pointed out they didn't reserve any right to file an appeal. After a long time, they have come with an appeal, and I'll place before your lordship how they have approached. They are relying upon some note sheet now, but things are not that simple, my lord. I'm coming to the note sheet. This is, I'm sorry, my lord, whether it is internal page number or continuation, I don't know. It is continuous.
Yes, it is continuous.
My lord, we will come to page 23. This is reference to CSD audit para 02 regarding non-rounding of the distance nearest to 0. My lord.
Page number.
Page 23, my lord. The top.
Of the
typed copy, that I read before, lord. Supplementary affidavit, I think.
Yes, supplementary affidavit, my lord. The note sheet just now, my learned friend.
yes, yes.
So there, lordship will find the period of contract 22 January 2018 to 21 January 2020. Then in the NIT, it is very important, lordship, because the distance to be covered in the contract of transportation is most important. It was fixed at 7. Thereafter, they issued letter of appointment to the contractor. There also it was specifically put as 7 kilometers. And there was a committee report.
No, why should we be on that? We are on the ground of delay. The petition has not yet been admitted.
No, my learned friends drawn attention of your lordship.
No, he wants to show that they have taken steps. So when the court has directed that what steps you have taken after the COVID, Period is over. That period they wanted
Even
explanation.
before COVID also, they had enough time, Lordship. They had to make the payment within 60 days.
Hmm.
But they didn't initiate any proceeding.
Hmm.
It was a afterthought only, because the COVID era came and they took shelter under that,
Hmm.
and they have come up on appeal. I'll draw your Lordship attention. Legal opinion, Lordship will find at page 26 of the note sheets. Lordship. May I read, Lordship? With regard to the opinion regarding taking legal opinion as to whether FCI needs to file an appeal against the court order, it is to submit that upon receipt of the court order dated 26/9/2019, the same was processed on file number so and so. Legal opinion was taken from Advocate B.K. Singh and Advocate P.K. Roy, my learned friend. Accordingly,
Reading where?
Lordship,
Page 27.
26, Lordship, 26. At the top, Lordship.
Additional affidavit. Supplementary affidavit.
It is in their supplementary affidavit, Lordship.
Open to the night.
Yes. Yes, please.
So, Lordship, my learned friend also gave his opinion. Accordingly, in consultation with regional, legal and finance, it was decided that the order of the Honorable Court may be complied.
Hmm.
That was the opinion of my learned friend. And thereafter, Lordship, in the next page, Lordship will find at page 27, there is a flaw in the judgment, as it is nowhere written, mentioned in the committee report that total distance covered by the loaded trucks was 6.7 kilometers. They are finding, Lordship. But I know. They annexed, Lordship, one committee report that is at page 63 of the same note sheet. It is dated 22nd September 2017. At the bottom, Lordship will kindly find paragraph 4, actual shortest distance. Clearly, it is shown that from railway siding Tinsukia to FSD Laipuli, it was 7 kilometers. That was the committee report. Only on conjectures they have come without explaining the delay. Lordship. time and again they have been saying. Six point 74%. So Lordship may kindly come to page 30. this time. Page 30, second para, Lordship. The advocate states that though the MTF Note 3 has been mentioned in the letter dated 25/8/2022, the fact remains that it is the FCI which constituted a committee for the purpose, and the said committee, after inquiry, had made its recommendation that, in the light of the above observations, the committee observed that the distance of 6.7 kilometers is actually involved during the movement of the truck ex-railway siding New Tinsukia FSD Laipuli, and the same may be accepted for setting the dues. After this finding, Lordship, what mistake the Honorable Judge had made when he stated that it should be 6.7, as their own committee has found out, my lord.
The basically we are in the condonation of delay petition.
Lordship.
Right?
No, they have brought all these things in the condemnation petition, Lordship.
So we are not on that. Whether the appellant could show the delay.
Yes.
It's beyond the reasonable limit, on that we'll see.
Lordship, the judgment was,
Of 19.
yes, Lordship.
And you have already received the amount
Yes,
as 7 kilometers.
Lordship.
Now, only thing is that 0.3 kilometers access and has a financial burden on it. Whether we should consider it or not. That's all we'll look into it.
So, Lordship, they have not explained from the date of judgment what prevented them to take these steps which they have taken later on.
When the payment was made,
Payment was that they have not also said.
Now website.
I'm not aware of that.
Payment in 2019 itself, November.
when
Because I have given my opinion is short. I said, make payment first and then you, this is, your lordship will find, I've given my learned friend has just read, both the advocates given the honorable court missed the starting point is note 3. There are some mistakes in the judgment. That's why I pointed out. But I said, before you do this, with 60 days time is given by the Rajya Secretary, make payment, otherwise you will be in contempt. So they made the payment first. And payment has been made in November 2019. We made it immediately within the time. Payment made, the lordship will find at page 36. There is a page 36, serial 5. The direction was given immediately to make payment, and then soon thereafter payment was made. Okay. Page 36. My lord, note 5, serial number 5. This office in Consulted Regional Finance Legal Division Standing Council by letter so and so dated directed the DOW cleared the dues as per the direction of the gave. The payment has been made, my lord.
note 5, where is it?
Page 36, serial number 5, my lord. In this regard, following are considerations. And 5, serial number 5. Opinion was sought for on this. And then after that said, make the payment first.
So far opinion is concerned,
Yes.
My lord, there is no dispute about the distance. What happened, my lord?
No, my lord,
I'm not, since my learned friend and I not married, that's why, my lord, that's why I just.
I may be allowed to conclude, then my lord friend will get one.
Okay, we'll pass the order. Anything he wants to make submission?
My lord, may I take lordship to the opinion of my learned friend? It is at page 29. It will not take much time, lordship. How they proceeded with the matter, lordship will get a.
Page 29 years.
Page 29, lordship at the bottom. In response, Sri P.K. Roy, by mail dated 4/9/22, had furnished his opinion, which may kindly be perused. I am reading the opinion, lordship.
Don't
If
go for
a-
the opinion. We are not on that.
Lordship.
We are not on that.
No, my lord, how they have proceeded, that is important, lordship. Because at page 31, they say the honorable court has cognizance of the recommendation of the committee, ignoring the administrative decision of the competent authority, that is to general manager for restrict.
See, it was pointed out that there was a delay.
Lordship, yes, lordship, I think this is one of the ground based on which a chance be taken for filing the appeal. These are important because they are taking a chance. I'm not on distance now, Lordship, but how they have explained the delay? They have not explained the delay. Only they have produced a note sheet before your Lordship.
There are instances where the Honorable Apex Court, considering the note sheet, have condoned the delays.
Yeah, this is all right, my lord, but what comes out from the note sheet, that is important. This is my submission, Lordship. Because period from 15/3/20 to 2/10/21, they need not explain. They are covered by the judgment of the Apex Court, Honorable Apex Court. But beyond that, prior to 15/3/20, how they proceeded, and after 2/10/21, how the time was consumed. They have not yet filed the appeal also, Lordship. No copy has been served with us. We do not know what is there in the appeal. Appeal file করেছে নি? Appeal?
File করি?
আমাকে copy জানা।
না, copy delay আছে না।
হ্যাঁ?
Delay condone হলে দিন।
না, copy তো file করে আমি জানাই কনফার্ম যে এই ডেটত file কৰিছে নে নাই।
এইটো note sheet annex কৰিছিল, filing sheet। Annex কৰিছিল। Filing sheet to annex আছে।
সেইটো appeal file কৰিলে copy দি দিওঁ।
Okay.
Deep review.
Mr. P.K. Royal and Council appearing for the appellant, FCI. And Mr. C. Sudhir and Senior Counsel assisted by MSC Counsel for the sole respondent / petition. List on 14 June
14, my lord,
6.
14, 6.
My very humble prayer, my lord. While considering their prayer for continuation, Lords will kindly take into account the merit of the appeal, my lord. There is-
We'll go on that. We're
There-
not on the appeal case. We'll be going on the merit of the condemnation.
My lord. Oblige me.
Yes, Mr. Ali, why this for orders?
My lord, we have filed this petition, my lord, for extending the time, my lord. Your lordship granted, my lord.
Where is our order?
Please, my lord. 9, my lord. Last portion, my lord. Page 16.
What is the reason why?
My lord, we got the copy, my lord, on 9/5. And due to communication gap, my lord, we could not communicate with them, my lord, and it was communicated with them, my lord, on 15/5. And due to ongoing election, my lord, the election officer also, my lord, could not, my lord, hand over the copies, my lord. So that we are unable to file our written statement. And election office, my lord, is till 4th, my lord. We are paying, my lord, another 6 weeks time, my lord.
No, of course not. Mr. Ali should be.
Because election office, my lord, is completely, my lord.
That means you have not applied.
No, they are
You
not,
said you had sufficient documents. What else you need?
my lord, the current, my lord, all, my lord, current documents, my lord.
You don't need, you not required current documents.
Lordship will kindly see para 18 of the order, lordship. Only 65, 70, and 97 are available. itu belega. The petitioner is directed to.
You have received on 9/5. You have communicated. What is
On
the
15/5, my lord. They collected. Para 18, lordship. The petitioner is directed to appear before the Learned Foreigners Tribunal, 2nd Dorong, Mongoldoy, in FT second case number 419 of 2010 on 27/5/2024 with a certified copy of this order. Further, on the said date, date of her appearance, she shall submit her written statement oblique reply as well as written evidence in affidavit in the said FT case along with the documents on the basis of which she proposes to rely upon. Lordship. On the said read petition, lordship. He relied on some documents, Lordship, on the basis of which this honorable court was pleased to remand the matter before the concerned tribunal, Lordship.
Earlier proceeding was ex parte, my lord.
Mr. Ali,
Lordship, name was also not same, my lord.
page number 9 of the writ petition. Para 12. What else you need?
There are 9.
Para 12. Page 9.
Page 9, para 12.
WC 3256, my lord.
Your writ petition in which this order has been passed.
They have sufficient documents to prove their citizenship.
We have 65, 70 and 97, my lord. Current, my lord.
What else you need?
Linkage, my lord, with the petitioner.
That's it. You
Lord.
said you had
So-
a sufficient document.
So 65, 70,
That is, you should
97,
have said at the time of-
2013,
While disposing of the matter.
Lordship.
By 11, by 10. Not beyond.
But at least 2 weeks time, we can leave it granted.
No, no, sufficient. Today is 31st.
Lord. Because otherwise, my lord, reference was also, my lord, on different person.
Now you are aware.
Lordship.
So notice has been issued. File whatever you like. File your objection.
Lordship.
The applicant as a petitioner filed a writ petition being WBC number 2356/2020.
Hmm.
Being dissatisfied with the order. Passed by order dated 29/10/2019, passed by the Lalit Fairness Tribunal Second, Dorong, Mongoldoi. No, don't write 2019.
Original order.
Judgment order dated 31/10/2018, passed by London Member Fairness Tribunal Second Dorong, Mongoldoi, in FT second case number 419/2010, arising out of reference case number 5376/98. Who find the petitioner to be a foreigner. Of post 25/03/1971. As well as the order dated 29/10/2019, passed by the same tribunal in Miss case number FT within bracket 2 14/19, arising out of said FT second case number 419/2010, whereby the tribunal rejected the review of the said order dated 31/10/2018, passed by the tribunal. Whereby the review petition filed by the applicant on 26/7/2019 under order 3A within bracket 2 for the 1964 order. Read with section 151 of the CPC for review of the order as such and such. Ordinate bench of this court, after hearing the parties and on perusal of the records of said F2 case number 419/2010 of the Fairness Tribunal Second Dorong, Mongoldoi, by order dated 24/04/2024, allowed the said writ petition of the applicant. He filed the writ petition, being with WPC number, directing the applicant to appear before the Fairness Tribunal Second Dorong, Mongoldoi, in FT2 case number, FT second case number 419/2010 on 27/05/2024, along with a certified copy of the said order, and further directed her to submit her written statement, public reply, as well as written evidence in affidavit in the said FT case, along with the documents on the basis of which she proposes to rely upon so as to prove her case and discharge her burden as required under Section 9 of the Fairness Act 1946, showing her linkage with her parents and grandparents. It is contended by the applicant that the certified copy of the said order dated 24/04/2024 was obtained by the petitioner on 09/05/2024, and there was some delay communicating the order to her. It is also submitted by the applicant that since the office of the Deputy Commissioner, Dorong, Mongoldoi, is presently busy with regard to the ensuing parliamentary election. And as such, she could not bring certain documents so as to file her written statement as well as evidence in affidavit, written affidavit in the said matter. Hence, the applicant has filed this application for extension of time by 6 weeks. To file her written statement or reply as well as written evidence in affidavit in the said application number such and such. On perusal of the records of WPC number 2356/2020 prepared by the petitioner, we have seen that the petitioner at para 12 of say WPC number specifically mentioned, specifically stated, or specifically submitted that she has sufficient documents to prove her citizenship. On being inquired, Mr. Ali, counsel for the applicant, submitted that the sentence Mr. G. Sharma, standing counsel, Home Department, appearing for the respected respondents, vehemently objected for extending further time to the applicant / state petitioner or filing her written statement / written reply as well as written affidavit in evidence, written evidence in affidavit in said application number such and such by her. On being inquired, Mr. Ali and counsel appearing for the applicant submitted that she needs to obtain certain voter list after 2013. Considering the entire aspect of the matter and hearing the learned counsel for the parties, we extend the date of filing such written statement of the written reply and the written evidence and affidavit by the applicant petitioner, namely such and such, in said application number such and such, on or before 14th of June. Elections and to appear before the tribunal. Said tribunal, along with the copy of the order dated Agor order as well as the past today.
While submitting the documents,
Rest of the observations and directions made in the CWPT number shall say 11. To that extent, this interrogatory application prepared by the applicant petitioner and settled.
while submitting the documents, Lordship, Lordship, proceeding may not be allowed to go beyond the repetition, Lordship.
No,
What
We are not going on.
Yes.
expert has
See,
been set aside.
basically,
It will be
whatever
test
is
trial.
already there.
Yes, Lord.
We came to the finding that the notice was not duly served upon the petitioner. That is why we are not
Yes,
passing that out.